videos, anything of that. I understand this is the AG case was transferred to AG.
Wait.
But this whole we don't have it.
This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years. What's going on here?
Your Honor, a lot of the things that he has requested simply don't exist. 4 body cam videos were located by a subsequent search by the detective sergeant now on the case.
So you said a lot of what is requested doesn't.
A prosecutor walks into a final pretrial hearing with evidence he found this morning but should have handed over 3 years ago. This is Judge Rosemary Aquilina's courtroom at the 30th Judicial Circuit Court in Michigan. Defendant Carlos Lee Anthony has been reporting to pretrial services for nearly 4 years on life offense charges. Defense attorney Ronald Berry has spent 3 of those years waiting for critical evidence referenced in the police reports. Under the Sixth Amendment, the prosecution is required to turn over all evidence completely and on time, a process known as discovery. Prosecutor Michael Dobby from the Attorney General's office is representing the state. In 22 years on the bench, Judge Aquilina has never done what she is about to do.
This is docket. This is Anthony. Yeah. And there's 2 files. I only have 1 listed. Is the final pretrial on both or on 1?
Yeah, well, the one, Your Honor.
All right, thank you. This is docket 23-131 FC People State of Michigan versus Carlos Lee Anthony. Counsel, your appearances for the record.
Good morning, Your Honor. Michael Dobie, P76671 for the people.
Thank you.
Good morning, Your Honor. Ronald Berry appearing on behalf of Mr. Anthony, who is standing to my left or right at the podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide you the truth, whole truth, and nothing but the truth on the penalty of perjury?
Yes, ma'am.
You get your hand out. Thanks for a suit. I've rarely seen defendants wearing suits, so appreciate that. Okay. Have you taken any medication yesterday or today?
No, ma'am.
Alcohol, marijuana?
No, ma'am.
Are you supposed to be on medication you're not on? Any sign of fever, COVID, or other illness?
No.
You had enough time to talk to your attorney?
Yes, sir.
And has there been a plea offer in this? This is a final pretrial.
There has not been, Your Honor, in discussion with the defense
I
attorney.
can't. I'm sorry, sir. You need to stay closer to your mic. We can't understand you.
I apologize, Your Honor. No, there has not been a plea offer made in this case. In discussions with the defense attorney, it was made clear that the defendant would only accept a misdemeanor, so there was no real negotiation beyond that.
First of all, I don't discuss the subjects of our negotiations. We had a conversation. I don't know that I ever said that he would accept any offer, let alone whether it's misdemeanor or felony. In this matter, he maintains its innocence, and we've negotiated as such. Where we're at right now is Mr. Dobie had indicated to me 3 months ago that he was going to follow up with law enforcement about getting discovery that's outstanding, and I haven't heard anything since. We don't have the body cameras, the motor vehicle camera videos, anything of that. I understand this is the AG case was transferred to AG.
Wait.
But this whole we don't have it.
This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years. What's going on here?
Your Honor, a lot of the things that he has requested simply don't exist. 4 body cam videos were located by a subsequent search by the detective sergeant now on the case.
So you said a lot of what is requested doesn't exist. And then what did you say?
4 body cams that had not been previously provided to my office were provided. They have been provided via a download link to Mr. Berry this morning.
Via what?
A download link, a link to download.
Download link. Okay. Is there outstanding evidence that you have not provided to defendants in 3 years?
No.
Are you?
Well, frankly, Your Honor, I don't. I'll have to talk to Mr. Dobie to find out when this stray email must have been sent for me to download some additional body camera. It's interesting. I'm being told that much of it doesn't exist, which what I'm asking for is body cameras and dash cameras. And then in the same vein, being told 4 body cameras are sent to you. I don't know. I guess I'll have to look at them. But I know there's lots of law enforcement that were involved with this. They're referenced in the police reports. And to be simply told they don't exist, I want to get some follow up on here. I guess I'll have to file a motion to compel, and we can get evidence.com records to prove whether or not they exist and what efforts Mr. Dobie has taken, well, any, to actually retrieve them.
Okay, I have a solution here.
And Court of Appeals is down the road if neither one of you like it. So today is the, what, 26th? No, yeah. My brain's already finished. Today's the 28th of January. Whatever's outstanding or whatever, can this be figured out by February 4th?
Oh, not that.
Why not?
Well, I currently have another.
Don't care. Because they have to come up with it. Not
Okay,
you.
there's only one me, and I have lots of words.
I know you do.
So
I know you
that
do.
quick, I cannot.
Wait a minute. You have a list of what you need, right?
Yeah.
Okay.
Well, I mean, I don't know what exists. But all police.
Not your job.
Yeah.
Not your job.
Sir, turn over everything that exists.
Yes, Your Honor.
You
That's
can
happened.
Go through, it's gonna take 10 seconds. You could do it right now. I'm happy to wait and go through your email on your phone. Just don't say anything yet. You can go through your email on your phone, whatever, and look, and if you never received it, I'm inclined to dismiss this.
Well, that part we clarified.
Okay.
He gave me back in November a download with 172 files. We had a screenshot,
Okay.
and I confirmed with him that I have downloaded those, and that even in his own material, that those do not include law enforcement recordings. He's at least providing an update that there apparently he found 4 police videos. I don't know. He's never emailed it, communicating with me about that. But if there's a download,
Where did you find those 4?
I'm sorry, I didn't find them. The detective sergeant now, I have no access to evidence.com or whatever the Lansing police use. But the additional 4 videos, so the entire Fred Prince 176 items. So sending everything again was sent this morning to Mr. Barry, like within the last half an hour.
Oh, so the 4 additional cameras were sent this morning, and I've received no additional information. Okay, now I understand.
Okay. Well, let me understand.
They didn't exist before this morning, apparently, Your Honor.
How long has this? Here's what we're doing. This case is dismissed.
I'm sorry, Your Honor. There's been no motion to compel. There has been you're dismissing these because only
I'm
because
dismissing these, so you
Mr.
go
Barry
and get your
says.
act together and you can reissue it. This file is 3 years old. This man is due a speedy trial, and this information is not new.
I rarely do this. I can't think of one time in 22 years I have done this, but this seems to me to be unfair and prejudicial, and you can reissue. You can take your time and reissue when everything's put together, and then we're going to do all this again. And am I causing taxpayers money? Yes, but you know what? This man has been reporting to pretrial services for 3 years. The date
Your
of
Honor,
this offense
respectfully, he is
Jim,
not.
if
This
you
has been on
interrupt
2
me again,
years.
you will be picked up and put in lockup for
Contempt.
So I'll give you a chance to talk, but you will not interrupt me, especially when you're on Zoom and I've given you the courtesy to not fall through the snow like everybody else and you're on Zoom. This offense occurred February 15th, 2022, and I am not a judge who just dismisses things lightly. And you can ask everybody in this town, you can go down to the Court of Appeals and you can do whatever it is you want. But this man has been under our charge for 3.5 years or so. And things have not been turned over until now. And now I'm hearing they need more and more time. There's constitutionally protected rights. When you all get your, and there's no statute of limitations on a life offense. So when the Attorney General gets their act together, so will everyone else. This is dismissed for lack of progress and prejudice.
What just happened has a name. It is called a Brady violation, and it comes from a 1963 Supreme Court case, Brady versus Maryland, where the court ruled that the prosecution must turn over all evidence that could help the defense, and they must do it in time for the defense to actually use it. Not the morning of a hearing, not 3 years later, in time. The reason that rule exists is simple. The government has the entire weight of law enforcement behind it. Detectives, labs, body cameras, databases. The defendant has a lawyer. Brady was the Supreme Court's way of saying that gap cannot be used as a weapon. 3 years of a man's life have passed under these charges. Judge Aquilina just found out the evidence existed the whole time.
Your Honor, I need to make,
Court of Appeals down the road. Yeah.
can I make a record here, Your Honor?
You can make whatever you want as long as it's respectful and don't interrupt me again.
Absolutely. Thank you. Yes, Your Honor. This case was charged by the Ingham County Prosecutor's Office. It was almost a year before the AG.
Sir, it's my part for you're gonna stay near your microphone. The Zoom, for whatever reason, is not picking you out very clearly.
Thank you, Your Honor. This case was originally charged by the Ingham County Prosecutor's Office. It came to our office approximately a year after that. For about a year and a half since I've had it, the defendant was on bench warrant status, not reporting. He has, despite repeated violations before and after that. Yes, Your Honor. He was on bench warrant status following a violation. He was just on the idea that he has been reporting to pretrial services for 3.5 years. That's not accurate.
Well,
I
let
don't
me
believe
just
that there
say
is
this.
any basis for this dismissal based on the
Sir, you
defendant.
gotta start again. The court reporter's not picking it up.
Your Honor, I don't believe that there is any basis in law for this dismissal based on the defendant's claim that there is additional discovery that has not been provided. There has been no order to compel, no motion to compel, and no showing that there has been any wrongdoing by any party here.
The bench warrant that I have was in 2024. We are in 2026. The first witness list that I have here from the people was in 2020, 2024, August of 2024. This is a final pretrial. My expectation on a final pretrial is that you are all ready. Now we go back to square one like when it was charged. And you certainly file a motion for reconsideration or do whatever it is you want to me, but this is truly unconscionable here. In August of 2025, he was held in contempt and served 17 days. So between August and now January, there was plenty of time for this evidence and the files from both sides to get in order. I don't know why we're at final pretrial and now there's claims of things that have been in possession of law enforcement and the Attorney General and I suppose the Ingham County prosecutors for all these years and not been turned over. So as far as I'm concerned, a lack of progress is violating a fundamental right to presumption of innocence and freedom. And believe me, I don't do this lightly. I understand these are life offenses. They're very, very serious. But so is the lackadaisical attitude, maybe on both sides, maybe on all sides. I don't know. I'm not going to stand for it. The resolution is to either file a motion for reconsideration or simply recharge the defendant. No, we're done with this file.
Your Honor, may I ask the court issue the order so I don't have to worry about an objection, 7-day rule and all that?
There's one right there. Print it. We'll send it over to him and I'll sign it. Just do the blank one. I'm not. So, sir, I suggest you're not skipping town. You got another file in front of me. I suggest that you are the most law-abiding person on the planet. I don't like what happened here. I don't like these charges. I don't like this whole situation. But you do have a right to a speedy trial and a right to have an exchange of information that is timely. And this is simply disturbing. And I know everybody's busy. No one knows that more than me. And I had 100% criminal docket. I get it. But this speaks to laziness on your part, your counsel's part, the prosecutor's part, the Ingham County prosecutor's part, and that's not a justice system. That's a lazy system. That's not what I'm going to tolerate. So message sent. They may very well reissue. So I suggest that you deal with your attorney and maybe you continue working on this. I really don't know. I'm not giving you legal advice, but they do have the option of reissuing this immediately, and they can do that. But message sent, I hope. That is all. I'm going to sign the order. We're going to, council's writing it. We're going to send it to you, server approval, or I'll just read it now in the record.
Yes, Your Honor.
This matter is dismissed without prejudice for the reasons stated on the record. Any objection to that, counsel?
No, Your Honor.
On behalf of the Attorney General?
None beyond what I've already stated.
Great. Send a message to your office. I expect timeliness, especially on a final pretrial. You all get your ducks in a row, or this will happen. I don't know what else to say. I have not done this in 22 years. But this does not sit well with me. But make sure you all get a copy of this. That's all it is.
Thank you, Your Honor.
Counsel, you have the next date on the second file?
Most people assume that if the government has evidence against you, they have to show it to you. That instinct is correct, but incomplete. Brady only covers evidence that is material and favorable to the defense. Courts have spent 6 decades arguing over what material actually means. The Supreme Court defined it in United States v. Bagley in 1985. Evidence is material if there is a reasonable probability that disclosing it would have changed the outcome. That is a high bar, and prosecutors have historically used it to justify late or selective disclosure. What Judge Aquilina did here bypasses that debate entirely. She did not rule on whether the evidence was material. She ruled that 3.5 years without a complete file is itself a constitutional failure. The right to a speedy trial under the Sixth Amendment is a separate and independent protection from Brady. It does not ask what the evidence was. It asks how long this person has been living under these charges without resolution. Both protections were violated here simultaneously. That combination is what made dismissal the only viable response. If you think the charges should have stayed regardless, tell me why in the comments.